So it's a pleasure to welcome all of you in this panel that will try to explore fascinating legal questions and also relevant geopolitical questions, for example, such as whether the law falls silent in times of war, or whether the law offers or can offer a meaningful way forward, and how it aspires to peace. And with the help of our distinguished experts, we will do our best to explore and unpack the principles and basic concepts of international law that might be relevant in the current conflict. And in doing so, we are looking for answers on how the law can guide us to reach the end of this tragic war. But please let me first introduce you our distinguished panelists. We have the huge privilege and pleasure of welcoming Réka Varga, the Dean of the University of Public Service. She is a former legal counsel at the International Committee of the Red Cross and an associate professor at the Pázmány Péter Catholic University. We have the privilege of welcoming Professor Miguel Ayuso-Torres, who is a renowned Spanish jurist and legal philosopher from the Universidad Comillas de Madrid, author of 30 books and several hundred articles on legal and political philosophy. We welcome Professor Akihiro Iwashita from the Hokkaido University, Japan. His research focuses on border studies and Russian foreign policy towards China and Japan. We also have the huge privilege of welcoming Sanjay Kumar Pandey, who is a professor at the School of International Studies at Jawaharlal Nehru University in New Delhi. His research interests include foreign policy and politics of Russia. And last but certainly not least, we have the privilege of welcoming Evans Ogada, who teaches public law at the University of Nairobi School of Law and regularly serves on civil society panels on international criminal law. And with that introduction, we are going to jump right into our important and hopefully revealing discussion. We have both legal and geopolitical experts on this panel. And the first question will rather go to the lawyers, but of course anyone can address the question. For various reasons, the armed conflict in Ukraine represents a major departure from previous wars. And one of the reasons is that the language of the law was introduced very early on in this conflict. For the first time in history, we can say, the war is not only waged on the battlefield of Ukraine with conventional weapons and firearms, but also before international courts or other institutions, from the ICJ to the International Criminal Court, with legal arguments. Just today morning news that the ICJ started the public 4 days long public hearing in the case of Ukraine v. Russia. And my first question is, to what extent do you think that did we overcome the old maxim of international law that inter arma enim silent leges, so in times of war, the law falls silent, and to what extent did this old maxim still prevail in the current war? And I would give the floor first to Réka to address this important question.
Thank you very much, and thank you all for being here. In my view, this is not the first time that states are using legal arguments very strongly to back up whatever action they are doing. What we can see now is the acceleration of this phenomenon. So waging war through legal means is not, in my view, by no means a new phenomenon, but something that is very much apparent in this conflict. And the old maxim which says that in times of war the law falls silent is something that we, in many cases, cite, but at the same time, you just mentioned a number of legal procedures that are going on with respect to this conflict. The one in front of the International Court of Justice, which concerns the interpretation of the Genocide Convention, which Russia used. This convention, or some of its arguments were based on genocide being the casus belli, according to their argumentation. There is a ongoing proceeding in front of the International Criminal Court, and there are a number of proceedings in front of domestic courts. And also, there are a number of proceedings going on in the international fora, not in front of judicial bodies, but, for example, the Human Rights Council has made an inquiry. There is the Moscow mechanism in front of the OSCE. So there are a number of procedures that were put in place by law and that they were activated through these legal measures with respect to this conflict. Also, when we saw terrible events happening, many newspapers, articles, but also experts cited international humanitarian law norms being violated, and again, a number of procedures have been put in place. Also, there is a discussion about setting up a special tribunal to try the crime of aggression. I'm not going to go into that now, but this is just to show that the legal mechanisms are in place and they are actually very much activated with respect to this conflict. I think it's also a natural phenomenon that states interpret international legal norms according to their own interests. Just one example: the arguments Russia had used to start this conflict, most of these arguments, or actually all of these arguments, if you look at them from a legal point of view, had already been used by other states as well, by Russia as well previously, but also by other states as well. The legal arguments for starting the war, for recognizing the independence of the eastern Ukrainian provinces, etc., etc., etc. So I think it's also important to just say out loud that it's a natural phenomenon in international relations that states are interpreting and actually applying international legal norms according to their own current interests, and this is what we see in a very large scale now. And I think that also our responsibility, all of our responsibility lies here as well, namely there are the international legal norms. And yes, everyone is using them according to their own interests, which can result in the widening of these rules, but it will have a price because in the end, the legal framework will be loosened as a natural outcome of this process. So I don't think that law falls silent, but I also think that we have to be realistic as to what achievements or what results the law in itself can reach.
Thank you so much for the insight. So the reference of law is very much present, and can we move on with Evans as an expert of international criminal law? What's your take on it, whether the law falls silent or not in this conflict?
Thank you. Jonapot, good to be in Hungary. Fantastic hosts. May I thank the organizers of this event. The rhetoric of law is prevalent in this conflict, and you have to understand that nations want to claim the moral high ground, be it Russia, be it America and her allies who are aligned against Russia. The morality of the law gives them a good face in the public. So that's why rhetoric of the law has to be reinforced, even if we stage some processes to show that we are abiding by the law. Now, that having been said, yes, the law is silent in terms of the process. And as the previous speaker has spoken to it, the very start of the war, where the war started, that was a violation of international law. Russia, and it's not only limited to the situation in Ukraine, we had Crimea, we had the Caucasus territory in Georgia. Russia has progressively and sustainably ignored international law. we have principles of international law, respect for sovereignty, respect for territorial integrity of states. Those are bedrock principles of international law. If you have disputes with regards to any territory, the requirement under the UN Charter is for you to go to the court, for you to seek mediation, arbitration. That's how you deal with it in terms of the law. You don't wake up and do what the United States did with Libya, with the various conflicts that we've had unilaterally started by the so-called big powers. The problem with the law and enforcement with the law has roots in the structuring of the international law and legal order. We have the so-called Article 27, Yalta Formula, which gave the so-called big powers the authority to police and superintend over peace and security issues within the United Nations, the so-called Yalta Formula, Article 27 of the UN Charter. If you have the United States, Russia, the Big Five, the P5, other UN Security Council, superintending and policing themselves with regards to police security issues in the world, you're definitely going to have a problem. In the common law, we always have this principle that you don't preside over an issue where you have interest. But that is the very same thing we have with the P5, where they are involved in so many things, but they want to preside over. Thank you.
Thank you. Indeed, the collective security mechanism is built on the great realpolitik of international relations. With the same question, I would like Miguel to address whether the law falls silent in this conflict.
So thank you, before all, to the organizers, and be so kind as to excuse my poor English. And I would say that the interpretation of this sentence by Cicero, it is not so easy as it seems in surface, because the sentence means, in reality, that self-defense or legitimate defense is substituting the impossibility and incapability of the state to act. So, as other sentence by Cicero also, salus populi suprema lex esto, which means state of necessity, both of them are complementary, but the significance is no, there is an incompatibility between war and law, but this mechanism of substitution of law when there is a situation of legitimate defense. But going to the point directly, in my opinion, today, as Réka said in the beginning of his intervention, this is not the first time we are assisting to this phenomenon. But today we have a total war. So we have talked about economical war, economical warfare, talking about sanctions, for instance. This is economical warfare. And we can talk also of juridical warfare. So is the law as an instrument of war. And in my opinion, we have taken into account this deep reality for understanding what is happening in this conflict, but not only in this conflict, but in general in the world situation.
Thank you so much for this insight. And Akihiro, could you address this question?
Yes. First of all, we share what crisis we now facing. I think that now new ice age has started. Even we can call it Cold War 2.0 or not. We can discuss the difference from the first Cold War. Anyway, post-Cold War ended, there are happy 30 years. Therefore, I think that this period I call interglacial period, borrowing from the interwar period, crisis in 20 years between World War I and World War II. So under this kind of concept, now we are faced dual challenges of international norm. First of all, the post-Cold War political international regime, also crisis, and more than that, the international law regime, since started end of World War I, also now is a crisis. So probably you know very well the peaceful resolution of conflicts or prohibition of war, and after World War II, it's part of the UN charters, non-use of force, the Genocide Convention also added, so on non-aggression, and etc., etc. I think Vladimir Putin is breaking down all of the international norms that we shared in the 20th century and early right now. This is the first point. The second point of that, the post-Cold War international norm was also undermined by Putin. Probably you know the term of uti possidetis iuris. It's a term of the you pose as you have. It means that the administrative border turned to be a national border because of avoiding the further conflict when you are independent. So you back to the history, Central America and Africa, then in the collapsed Soviet Union and in the post-communist world, we applied this kind of uti possidetis iuris. But some exception, some independent country occurred from the autonomous region, not republic sovereignty. So the Chechen was the case, was also the South Abkhazia, or de facto state, but unrecognized. We ignore these unrecognized states in the interglacial happy 30 years, even they are independent factually. But we opened the Pandora box in 2008. This is the independence of Kosovo. We rushed to recognize that. But Putin said that, okay, this is the influence of uti possidetis we shared. So he began to undermine the post-Cold War international norm also. This is a consequence of the Crimean annexation and currently situation. So again, I said that we are now facing the unexpected crisis, and on political, of course, but in also international norms, in kind of we are now really crisis of the world.
So the international law is in crisis. Thank you so much for that insight as well. Can we take a step back and see these events from a geopolitical perspective? And I may start this observation with maybe with the long telegram in 1946, 46, yeah, and the X article, so the sources of Soviet conduct in 1948, and George Kennan. And since that time, the West has been very aware of the insecurity, of deep insecurity of Russia. It's a huge country, and therefore it has huge defensive capabilities and resources. But because of it's a huge country, it's always vulnerable somewhere. So the situation is often called a permanent emergency, so to speak. And partly the Budapest Memorandum, so after dissolution of the Soviet Union, the Budapest Memorandum in 1994 was addressed, or trying to address this question, at least in part. And my question is to you, Sanjay. How do you see the chain of events that led to this conflict, considering this long-standing observation of the West, the insecurity of Russia, and the Budapest Memorandum?
Thank you, MCC, for inviting me. Coming to your question, in your initial observations, you referred to two concepts. international law, and geopolitics. And the two do not go along very well most of the time. Geopolitics starts where law ends, I'm afraid. Coming to the long telegram and George Kennan's observations about Soviet behavior or Russian behavior in general, he talks about Russia's insecurities from time immemorial because of its backwardness, because of what he says the vast expanse, and because of the existence of many hostile tribes, the Mongols and others, who invaded, occupied Russia in the 19th, 20th century, because of, he does not really talk about some of these, but one can add, because of what the French Napoleon did, what Hitler did. So the insecurity has a long history. But at the same time, Kennan also says that Russia is fundamentally weak vis-a-vis the West. So its insecurity and its weakness defines its conduct in many ways. I would refer to a more recent article that he wrote. In fact, 50 years after his long telegram, as recently as 1997, that was 25 years before the Ukraine war, 50 years after the long telegram and 25 years before the current crisis. And I would like to read out because it's very, very perceptive and apt. And he says, Kennan says, why, with all the hopeful possibilities engendered by the end of Cold War, should East-West relations become centered on the question of who would be allied with whom, and by implication against whom, in some fanciful, totally unforeseeable, and most improbable future military conflict. So he was almost predicting the present conflict. He goes on, bluntly stated, expanding NATO would be the most fateful error of the American policy in the entire post-Cold War period. Such a decision may be expected to inflame the nationalistic, anti-Western, and militaristic tendencies in Russian opinion, to have an adverse effect on the development of Russian democracy. NATO expansion, he is linking it to Russian democracy, undermining of Russian democracy, and rise of ultra-nationalism. To restore the atmosphere of Cold War, NATO expansion is likely to restore the atmosphere of Cold War and East-West relations, and to impel Russian foreign policy in directions decidedly not to our liking. How apt. He almost predicted what's going to happen 25 years later. So, and of course, since yesterday we heard so many speakers, that was a pleasant surprise to me, who all talked about the follies and the mistakes that US and NATO has made. Of course, the follies are compounded. I would say NATO expansion is in many ways the most prominent and the last straw on the camel's back maybe. But there have been many such actions which have added to Russia's insecurity and which the Russian leadership, and I would also say that public in general, has viewed in antagonistic terms. There was reference to what happened in Kosovo, NATO's bombings, and then NATO expansion, followed by what Russia sees a continuous attempt by West, by US, to undermine Russia's status in the global affairs. So basically, it is about great power politics. So regime changes. Iraq can be considered as one example, 2003, and without proper authorization from UN Security Council. Then 2004, Ukraine, Orange Revolution, 2000, before that, Georgia, 2003, 2005, Kyrgyzstan, 2010, again Kyrgyzstan. So Russians see it as an attempt by, they talk about sovereignty, they talk about inviolability of sovereignty. It's another matter that in recent cases they have themselves done it. But so this is the Russian perception that the West and NATO has been trying to undermine Russia and its security.
Thank you so much. From a geopolitical perspective, we maybe say that the inventor of the containment policy, George Kennan, has been contained in the past decades. Miguel,
May I add something? Yes. Because it's very interesting what we have heard, and you have in your question you have make reference to the word chain of events, and in the title of our panel there is the word sovereignty. Ukraine has never existed before the Soviet Union. When Ukraine was born, Russia had no difficulty, even when it became an independent state. And Russia had no problem with that fact, because Russia has no state mentality and state ethos. Russia has an imperial ethos. Imperial ethos means the existence of some independent states, but if they remain in its orbit. So when NATO, the United States, and the European Union began to push and to change after the coup of 2014, the situation, it was the precise moment where Russia reacted. So without understanding that state mentality is absolutely alien to Russia thinking, but an imperial ethos is in the deep of its thinking.
Thank you for highlighting this. Akihiro, the last word is to you.
I just follow the one moment. You're right. So this perception of Russia, because the kind of the perception is very dangerous, because Ukraine is artificial state. Therefore, Putin never recognized Russia, Ukraine as an independent state. This is one reason why he prefers using a special military operation, not the war itself, as you said that. So this is the kind of the Ukraine, a nation on borderlands. Professor Karl Schroeder, German, said, but this is true. If you look at the Hungary so many influence many imperial other neighbors, but Hungary has a core kingdom, Ukraine never. But it's very dangerous because Professor Pandey is different. But I heard Indian militant said that Pakistan is artificial state. It ceased to be soon. So such kind of a dangerous method, I completely disagree. Once it created the space as an independent state, we should keep it. This is Uti hypothesis. Thank you.
Thank you so much. Can we move on to the next question, because it's also a very interesting legalistic aspect of the conflict. So, a unique feature of this war is the financial resources and the modern weapons and technology, as well as the information the Western powers are providing to Ukraine. It can be said that Western technology has also become, to a certain extent, a participant of this war. Western technology is also waging this war. We see drone attacks, HIMARS, various rockets, cyber attacks, and yes, the Western tanks and fighter jet may soon become part of the battlefield landscape. Now, my question is from an international legal point of view. What is how does international law see it, and what is the conduct or the intensity of the participation that can transform a state from a non-belligerent country to a belligerent one, and who can qualify this, and what are the consequences of this? And Réka, maybe first I give you the floor.
So thank you very much. Yes, this is in one way, $1 million question. International law doesn't have a precise answer to this. So there are no clear lines or definitions or conditions in which moment you would say that from this moment on a state is a participant to an armed conflict. Eventually there are political statements and opinions answering your question. In the end, if there would be a court case where this would be brought up, a judge would qualify this. So far, this precise question has not come up in front of any international courts. There were similar cases with similar questions, so these are the ones from where we can draw certain consequences. So what the line we can draw is that on one side we can say, based on international law and based on these specific previous cases, that it's definitely not enough to provide weapons, to provide financial support, or even to provide training to a given state to make this supporting state a belligerent country, to make this supporting state a participant in the armed conflict. On the other side, probably where it will definitely amount to participation in an armed conflict would be, but again, I'm saying probably because there is no express treaty or other kind of international legal maxim saying this, if military operations are very closely coordinated, carried out together, planned in a very close coordination with another state, and to a certain extent, if this kind of support and this kind of close coordination amounts to or can amount to causing harm to the enemy or to the other side, again, we are talking of very close cooperation in the execution of the military operations, then at that point, probably international law would say that the supporting state is also a participant to an armed conflict. But again, coming back to the first thing I have said when I started my intervention was, this is the legal understanding, or this is probably the legal understanding of the situation. What really counts is how the states see it, because in the end, what we count is when the other side or when the supporting side says basically or considers it also politically that he or that state is a participant. Let me just tell you one example. If you look at the the official statements by the US, to a certain extent they were contradictory, but in certain instances, especially the sensitive cases, they made it very articulate that they are only providing equipment, information, etc., which is necessary for the defense of Ukraine, referring to the self-defense situation in which Ukraine is reacting to an aggression, and they also said at certain instances that they are not providing weapons or intelligence or information that will be used to actually kill Russian soldiers or that would be used to actually engage in an active attack. Now, whether this is true or not, I don't know. I don't think you know, or any of us knows. But this was important that they articulated this way, and I haven't seen any Russian official position when they would have, they warned, then they were concerned, but there were no instances when they were actually saying that, well, I count this as an aggressive as an intervention in the armed conflict. So in the end, I think this is what will count, whether it's in the interest of the supporting state or the other state, in this case Russia, to see it as a participation in the armed conflict.
Thank you. Others I would like to address?
Yes. In the spirit of fairness, the West has been accused of actively supporting Ukraine. It's correct. It's factual. The evidence is out there. Ukraine is getting support from the West. But there are counter-arguments that Belarus, for example, has been offering material support to Russia. President Lukashenko has been accused of offering military bases and material support to Russia. Now, like the previous speaker has said, this is a gray area in international law. I have seen arguments, though, that to transpose a country from non-belligerent status to belligerent status, we have to look at specific contexts. Each occasion has to be looked at on its own merits and with regards to its own facts. And when that will be done, we will rely on principles of jus ad bello, the laws of justice of war, whereby we will be looking at circumstances like the last resort. Was there a just cause for like self-defense? Was the declaration of war made by lawful authority? Did we follow rules of proportionality? Is there a likelihood of success? All these principles will be looked at on a case-to-case basis. So it's hazy, but there's argument that jus ad bello could help.
Thank you, Miguel, and then Réka. Yeah?
Oh, thank you. It's very interesting, the question. But once upon a time, there was a distinction between belligerence and neutrality. But we are talking, in your question, not about neutrality, but non-belligerence. So things has been complicated, and why? In my opinion, because the law of war has disappeared. And why has law of war disappeared? Because of ideology. Better, because of a concrete ideology, pacifism. Because pacifism has not suppressed war, but has suppressed law of war. So, in this context, I prefer not to answer in an articulated way, but with 3 examples. First, President Biden. President Biden, before the German Chancellor, referring to Nord Stream 2. We will put an end to it. First example. Second example, Boris Johnson. Putin must fail, and Putin must be seen to fail. I could go on, but in my opinion, it is better to stay with 2 examples. It is enough.
Yes. Microphone. What I was intending was not to justify what Russia did in Ukraine, but to try and understand what he did and why it did. I mean, why Putin did or Russia did. So, again, coming to geopolitics, Professor Jeffrey Sachs yesterday talked about innumerable occasions on which the Russians warned NATO about expansion and what could be the consequences. I would just mention 1 or 2. When the red lines were crossed, first week of April 2008, that was the Bucharest NATO summit, in which for the first time, Ukraine and Georgia were formally invited that the process of negotiation for membership would start. This was April 2008, and August 2008, we had the Georgia war. Was not that a signal enough how Russia is going to react? Then 2014, Yanukovych, as the Russians or Putin called it, a coup, and it was repeated by many others. And just after that, the Crimean occupation or reintegration depends on where you stand. So again, that shows that Russian actions were predictable, may not be justifiable, but predictable. And
you are right, 2008, Kosovo's impact.
yes, yes, definitely. Kosovo, they talked about, if you can do it in Kosovo, why not Crimea? Yeah. If referendums are justified in one place, they are justified elsewhere also. It's another matter that Europeans did not send their observers for the March 2014 referendum in Crimea, good or bad, but they did not. So that is the whole point I'm trying to make, that we can see a pattern. There was predictability which was ignored. The question was whether they wanted to remove Putin, to defeat Russia, or to bring peace. If Ukraine had heeded, I mean, the basic fundamental problem is that after the end of the Cold War and end of, with the unipolar moment, the US foreign policy was guided less and less by realist calculations and more by liberal internationalism, promotion of democracy and humanitarian intervention. If it was guided by real politic, perhaps the war could have been avoided.
Thank you. We will continue with the President of Russia, but before that, I will circle back to the legalistic, non-belligerent, belligerent question. And Réka, you have a comment.
Yes, I think it's just important to make a difference, as you have referred to it, between two legal questions, whether one question is the question of the right to resort to force, and some of you have mentioned Belarus and its participation, and there is a claim, and I think a very well-founded claim, that Belarus allowing its territory to be used for Russian military operations also commits aggression, violating the UN Charter. That's one thing. And another, and from the perspective of the states that are supporting Ukraine, based on the UN Charter, they have the right to do this under the notion of collective self-defense. So that's one question, whether they would have the right to intervene. Yes, they would, in assisting Ukraine in its self-defense. And another question is what you have asked at the beginning, is whether they are factually in an armed conflict with another country, namely in this case Russia. So these are two different notions which need to be separated.
Thank you for the legalistic clarification. My next question, I addressed to every one of you my next question. The International Criminal Court recently issued an arrest warrant against the President of Russia and the Commissioner of the Children's Right of Russia. I do not want to speculate on the outcome of these arrest warrant. Instead, I would draw the attention to a very interesting fact that if you consider the state reactions, the various state reactions to that decision. And if we go a little bit of time travel, almost 1.5 years back to the initial aggression, what we could see is that only 30 out of the almost 200 states, so it's 15% of the states, remained silent 1.5 years ago when the aggression happened. Now, when the ICC issued the warrant, the situation is just the opposite. Only 43 states, that is 20% of the total states, said anything at all. And out of the 35 states that have issued favorable statements, 30 are either NATO or EU member states. Now, based on these state reactions and the shift of these state reactions, how, in your view, do the rest of the world really see this conflict, and why do they see it differently, than the West? We can start with Akihiro.
May I develop just a legal question? Just I tell the another world's view on the issue. Okay, so before like that, just one word to Professor Pandey. So yesterday, I'm impressed by the Jeffrey Fox saying, but he completely missed Obama's reset period. I'm shocked because 2011, there's the sanction against Libya. Russia did not reject in the ANSOC under the Medvedev president. Then 2014, then everything changed. So in this sense, it's too early to decide the 2008-9 the non-returning point. I should say about we do not simplify the process of these days. So back to your questions. So concerning China is very important. Of course, India is also important, but probably a professor said that of India's position. So why China is very important? Because the China factually support for Russia's aggressions. I think that in the international law norms, so Russia's Putin's saying that a bit sounds archaic. He wants to be respect Russia more, like in 19th century. His thinking looked like kind of back to the concert of powers when Russia was fully respected in Europe. So I think that if we position the international norm as operating system of the computer, so we keep the current OS, operation system, US, Japan, and the EU supported, keep it right best, then we angrily react to the Putin's aggression on back to the 19th century's the operating system. China prepared new operating system in 21st centuries. So what does it mean? China to think that, this is my personal thinking, Russia is a bit too many things, too rash, but it's not so bad. Break down the current operating system. Breaking down the current operating system, new system should be launched on. Then China prepared. It means that China, why? Looking support, it's Russia too much, but it's a good chance of China's new operating system coming on. So this consequence, what OS you love? This is my suggestion.
Thank you so much. Sanjay? Yeah.
Yes. You referred to George Kennan's long telegram and the policy of containment, the start of the Cold War. In the same years, India became independent, 1947. But even before independence, 1946, long telegram year, the same year as the head of the transitional government, the first prime minister, later prime minister, Jawaharlal Nehru said, as far as possible, we would like to keep away from power politics of blocs aligned against each other, which have in the past led to great wars and which may in future lead to greater catastrophe. Since then, the effort of India and many of the decolonized states of Asia and Africa has been to carve out their own independent position and niche in the international system, and not exactly joining one bloc or the other. So that has been India's consistent position. In the recent conflict, in fact, just after the Crimean occupation, the government of India and our national security advisor at that time said, first, he disapproved of any use of force to settle disputes, but then he said, we believe that Russia has some legitimate concerns and interests which need to be taken into account. India's position has been that we have our own worldview. We have our own historical, cultural experience. We have our own problems. We have our own national interest. We will decide about each issue based on our own understanding of the international situation and our own national interest. The fact that Russia has been a consistent friend of India, it's no secret that more than 60–70% of military supplies India gets from Russia. Russia has been consistently supporting India, Soviet Union earlier, in UN Security Council. But more than that, our our own independent position and autonomy has defined our position on the Ukraine war. While Prime Minister Modi clearly said in September 2022 at the SCO summit, this is not an era of war. That was a clear indication that we do not approve of war. Mm-hmm. But beyond that, we have our own interests and concerns. Thank you.
Thank you. And Evans, how does Africa see this conflict?
Well, from an African perspective, and when you speak of Africa, you have to tie Africa to a greater part of the Arab world. The indictments and the war have now been fused with the entry of the ICC. The ICC always excites division, binary division in the continent. There are those who see the ICC as a hegemonic tool, a tool used to further certain interests. They argue that the ICC will readily issue indictments against African leaders and those from the so-called third world, but when we seek indictments against Israel, Blair, Bush, then the threshold is not met. So that will always be a problem with the ICC. Now, other countries like South Africa, and South Africa has been very vocal internationally on this. The Foreign Minister, Naledi Pandor, has been quite vocal on this. There are historical ideological reasons, and especially when the history of the United States comes into play. You did not support us during apartheid. You sided with our oppressors. The Palestinian question. This is also another issue that will breed emotion in Africa and in the Arab world. So these are concerns, not a straight answer to the question.
Thank you. Thank you so much. And we have one more question left that is aligned with some of the audience questions. And this is the role of international law and the role of international dispute resolution to end and to give the tools to end this war. And based on historical experience, I may see a shift between the pre-1945 period, when big conferences like the Congress of Vienna, Congress of Berlin, or the Treaty of Versailles discharged that peacemaking function, and the post-Second World War era, where big powers, especially the United States, played that role in mediation and good office. If you think of the Camp David or Tashkent or Dayton in terms of Yugoslavia. How do you see this shift? How does international law facilitate and can facilitate a ceasefire and subsequent peace talks? And what is the potential role of China in this? And maybe we can, each of you will have 1 minute, and maybe we can start with Miguel, because
very shortly.
Yeah, very shortly, because we're limited time.
I think the decadence of law of war, which I have talked about before, it's very important also in this step. So peace treaties and all these kind of instruments are in decadence, totally. So today, but perhaps it is not so important because entering in a conflict is very easy, but leaving the conflict is so difficult. Imposing sanctions is very easy. Lifting the sanctions is very difficult. So I do not think is international law the most important instrument for solving the crisis and the problem. Other aspects which can be taken in consideration.
Thank you.
If you prepare China's new version of operating system, rely on China, but please care about the democracy, societies, human rights. So I don't know if you love or not. But more, I prefer India, because India is very well balanced. They blockade sometimes the kind of quad the sanction, but also India blocked Shanghai Cooperation Organization unions. So in this sense, India as a leader, or one of the leaders of non-alignment and the neutrality, it's a different term in the colonial, decolonized period. Now it's many countries independent. But India, they are good position to manage that. So I don't know if India really do that, but this is a question to you.
Well, yesterday we heard the Indian diplomat who said that this is a very crucial year for India because we are having the SCO presidency, and the SCO summit is going to take place sometimes in July. We also have the presidency of G20, which is a very influential, and there is a feeling that during both the summits, the issue of Ukraine is going to dominate, and it is anyone's guess, and it will take all the, diplomatic abilities of India to come out with a consensus statement. I hope we will be able to. So we have not openly proclaimed our intention to mediate, but these two events can be pointers how and what role India sees for itself in future with regards to the Ukraine conflict.
Thank you. Evans?
Well, the ideal situation will be to deal with this conflict using the tried and tested methods. We have Chapter 6 of the UN Charter giving us tried and tested formulae. However, with the ego, the anger that is brewed in this conflict, it makes it difficult. I'm reminded of Johan Gatlung's peace theories. This is difficult. It will need more than the law and the institutions in place. Perhaps something from Africa would help the conflicting parties in this one. In Africa, we have the spirit of a philosophy called Ubuntu. Ubuntu came in handy when South Africa was staging reconciliation. The spirit of Ubuntu was called upon in Rwanda post the 1994 conflict. What does Ubuntu mean for the non-Africans? Ubuntu simply reduces to humanity, humanness. See the Russian, see the Ukrainian as a brother or a sister. The liberal world order has reduced us to robots, atomic pieces, chess pieces on a board to be pushed and moved anywhere. With Ubuntu, the emphasis is on community. Let us go back to those first principles whereby we are first and foremost moral beings, then the law and the systems will work. Thank you.
Thank you for this insight. And Réka, the last word is yours.
That's frightening. I fully agree that the international law will not solve this, nor did it solve any conflicts. In the end, it's always a political solution. But international law can provide frameworks and tested mechanisms, such as the ones in Chapter 6. And it will be interesting to say, I wouldn't dare to predict who could be mediating in brokering such a political agreement. But first of all, the essence of mediation is that both parties accept the person or the institution of the mediator, which is a very important point, and it's already in itself a very sensitive question. And just my second point, and with this I respect the time frame, I hope, is that the legal framework is sometimes in contradiction with reality. Just one point to take away, in the post-1945 international legal order, international treaties that are a result of a use of force are invalid. So peace treaties which are a result of a use of force are invalid. So, in a case where an attacked state against which force was used gives up territory and enters into such a peace treaty, would be invalid according to international law. At the same time, it did happen, it could happen, and there could be a situation where the concerned states and the international community would de facto accept such a situation and would accept such a treaty. Still, the law would clearly say it would be invalid. And this is just something that I put on the table. This dichotomy, again, between law and reality is interesting. Thank you.
Thank you so much, and thank you so much for the insightful contributions that were putting so many different perspectives from around the world on the table in this panel. I thank you for the audience for being so attentive and for the excellent questions and well. Please give a big nice of applause to our wonderful panelists.